Got some breaking news. Former NFL star Aaron Hernandez expected in court at any moment, and here he is being arraigned on 2 counts of first-degree murder. He's accused of killing 2 men in a drive-by shooting back in 2012. Let's listen in.
Court. Court's in session. Please be seated.
Docket number 2014-10417, the Commonwealth versus Aaron Hernandez. May the warrant be recalled, Mr. Magistrate.
Yes, sir.
Has the order of notice been read, Madam Sheriff?
Read 3 charges.
May I proceed with the arraignment?
Yes.
Aaron Hernandez, please rise. On May 15, the year 2014, the grand jury in the County of Suffolk returned indictment number 2014-10417-001, charging murder in the first degree. Commonwealth of Massachusetts, Suffolk SS, at the Superior Court Department of the Trial Court for Criminal Business, begun in Holden at the City of Boston, within and for the County of Suffolk on the first Monday of May in the year of our Lord 2014. The jurors for the Commonwealth of Massachusetts on their oath present that Aaron Hernandez on July 16, 2012 did assault and beat Daniel D. Abreu with intent to murder him, and by such assault and beating did kill and murder Daniel D. Abreu. How do you plead this indictment? Are you guilty or not guilty?
Not guilty.
Offense 2, charging murder in the first degree. The jurors for the Commonwealth of Massachusetts on their oath present that Aaron Hernandez on July 16, 2012 did assault and beat Safiro Furtado with intent to murder him, and by such assault and beating did kill and murder Safiro Furtado. How do you plead to this indictment?
Not guilty.
As to offense 3, charging assault with intent to murder, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
As to offense 4, charging assault with intent to murder, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
As to offense 5, charging assault with intent to murder, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
As to offense 6, charging assault and battery by means of a dangerous weapon, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
And as to offense 7, charging possession of a firearm, not at home or work, no license, do you waive the formal reading of this indictment?
Yes.
How do you plead to this indictment?
Not guilty.
All right, counsel, could we kindly identify yourselves for the record, please, just so we have everybody's name on the record for counsel?
Charles Rankin for Mr. Hernandez. May his handcuffs be removed, Your Honor?
Not presently. The sheriff has asked that they remain.
James Sultan for Aaron Hernandez.
Michael Fee for Aaron Hernandez.
Good afternoon, Mr. Magistrate. Patrick Hagan for the Commonwealth.
All right, thank you.
Good afternoon, Teresa Anderson on behalf of the Commonwealth.
All right, Mr. Hagan, on behalf of the Commonwealth, does the Commonwealth wish to say anything at this
Yes,
point?
Mr. Magistrate. The Commonwealth is requesting that the defendant, Aaron Hernandez, be held without bail. The indictments before this court arise out of a comprehensive, multi-month grand jury investigation by the Suffolk County District Attorney's Office and the Boston Police Homicide Unit. This investigation yielded significant evidence, including video surveillance analysis, cell site location information and records, forensic testing, eyewitness identifications, and witness statements and testimony. This evidence established that on July 16th, the year 2012, at approximately 2:30 a.m., the defendant, Aaron Hernandez, armed with a .38 caliber revolver, shot and killed 2 men and injured a third as the victims were stopped at the intersection of Shawmut Avenue and Herald Street in the city of Boston. The driver of the victim's vehicle, 29-year-old Daniel D. Abreu, suffered fatal gunshot wounds to the chest. The front seat passenger, 28-year-old Safiro Furtado, suffered fatal gunshot wounds to the head. 2 backseat passengers escaped without injury, and a third backseat passenger suffered a non-life-threatening wound to his arm. The sequence of events began the previous night, Mr. Magistrate, on Sunday, July 15th, the year 2012, at approximately 10 p.m., when a defendant and a second person left Manchester, Connecticut, with plans to go to the Cure Lounge, a nightclub in Boston. The second person is a friend and associate of the defendant known to the Commonwealth. The pair traveled in a 2006 silver Toyota 4Runner SUV, a vehicle that had been provided to the defendant as part of a promotional arrangement with a Rhode Island car dealership. The SUV was owned by and registered to the dealership and not to the defendant. Just prior to leaving Connecticut, The defendant was observed to place a revolver into the engine block of the SUV where it was hidden but easily accessible. Evidence suggests that in the months leading up to July 2012, the defendant had become increasingly sensitive and angered by what he believed to be people testing, trying, or otherwise disrespecting him when he frequented nightclubs in the area. At approximately 12 a.m. on July 16, 2012, the defendant and his friend arrived in Boston and parked in a garage at 274 Tremont Street, a short distance from the Cure Lounge. By coincidence, Daniel D'Abreu, Zafiro Furtado, and 3 of their friends arrived at the same parking garage within 5 minutes of the defendant. The victims had traveled to the theater district from Dorchester in a gray 2003 BMW owned by Mr. D'Abreu's sister. They had previously socialized together at a family Dorchester cookout. None of the victims had been to Cure prior to that night. At approximately 12:30 a.m., the victims entered the foyer area of the Cure Lounge. As they showed identification and paid a cover charge, the defendant and his friend were escorted into the nightclub by a Cure employee. Witness testimony, corroborated by surveillance video from the entrance to the nightclub, indicates that there was no interaction at this time between the defendant and his friend or any of the victims. There is also no evidence that the victims and the defendant knew one another or had ever crossed paths prior to that night. In fact, none of the victims recognized the defendant as someone they had seen before, either in person or otherwise. The defendant and his friend proceeded downstairs, purchased drinks, and stood at the edge of the dance floor. Shortly thereafter, Daniel D'Abreu, while dancing nearby, accidentally bumped into the defendant, causing the defendant's drink to partially spill. The defendant became angered and increasingly agitated, particularly after Mr. D'Abreu smiled and did not apologize. There was no observed verbal argument between the defendant and Mr. D'Abreu, and there was no physical contact between them beyond that initial bump. In fact, neither the victims nor the security staff at the club were even aware that the defendant had become angered or agitated as a result of the incident. The defendant told his friend that Mr. D'Abreu had deliberately bumped him and was, quote, trying him. The defendant's friend quickly convinced the defendant to leave the nightclub and walked him outside just 10 minutes after their arrival. The defendant was captured on surveillance video, quickly consuming 2 mixed drinks as he walked out of the front door of Cure Lounge. For the next 5 minutes, the defendant's friend attempted to calm the defendant as they paced back and forth on the sidewalk leading towards the parking garage. Video surveillance from the outside of the nightclub captured this interaction. The defendant and his friend then walked across the street and entered another nearby nightclub. Within 15 minutes of their arrival at the second nightclub, the defendant pointed out a small group of men now entering that club. The defendant told his friend that this group included the man who had bumped him and spilled his drink. The defendant again voiced his belief that he was being targeted and disrespected by this individual and his friends, and that he believed they were now following him from Cure. Witness testimony and video surveillance revealed, however, that the defendant's belief was mistaken, as the victims never left the Cure Lounge until after 2 a.m.